And you'll see these are almost all in our favor, but it's just increasingly specific. Then in 92, in the Lee versus Wiseman case, there were officials that were offering prayers at ceremonies, but the people were not required to be at that ceremony. So they're not really saying you have to pray. They're not even saying you have to be at the ceremony. We're just going to pray on our own up there, where I'm at right now, in front of everybody. And the Supreme Court said, no, you can't do that because you're advancing religion. Even if it's not strictly compulsory to be there, you're still trying to advance religion by doing that prayer as a government official, and you can't do it. And then in 2000, a student body got together, and as the student body voted that praying in school was okay. And that went to the Supreme Court, and they said, no, you can't actually vote as a student body and say to do something unconstitutional. So they struck that down. And then in 2002, this is in California, there was a recitation of the Pledge of Allegiance in classrooms. So this is already struck down. But each House of Congress passed resolutions reaffirming their support for this pledge, right? The Senate vote was 99-0, right? The House vote was 416-3. I don't know who those three are. The Supreme Court heard arguments in both cases. In this one, unfortunately, there were procedural matters that were violated, and so they lost the case, but because of procedural matters, not because of the content. So it came back up again a few years later, and then basically the Supreme Court came out and said, you cannot, this is where they changed this, you cannot as a government pass resolutions or laws that are strictly to interpret the Constitution. That's the Supreme Court's job, not the job of the House or the Senate. And so they basically shot down the House and Senate's vote, even though it was 99-0 and 416-3. Brings in doubt whether or not we're really a democracy, doesn't it? If the Supreme Court can actually say the Constitution overrules what the people want. It's an interesting thought. So these have to do with, make sure I'm on the right thing here, has to do with displays of religious. Yes?
I'm sorry to interrupt, but just a quick question. Couldn't they procedurally vote to amend the Constitution if they had a large enough majority? Then the Supreme Court would then be subject to having to interpret.
Yeah, I think they can, and there's been a few discussions about trying to rewrite the Constitution. And can you imagine the politicians today writing a Constitution? They can't agree on anything. I mean, with the two parties, I don't know how they would possibly. They're not of a mindset of doing what's best for the people. They're in a mindset of doing what's best for their tenure or their party. And there have been a lot of debates about a need to rewrite the Constitution because it's old and it's not necessarily what the people want nowadays, and they almost always go nowhere. And I think you're right; they could. I don't see it coming about. So, but they're allowed to make amendments to it. But according to the Supreme Court, they're not allowed to make amendments to it that are to interpret the original Constitution. They can make amendments to it to change things, but not as an interpretation, and that's what they were doing here. Which is interesting, right? It certainly gives the Supreme Court a lot of power. Maybe too much.
The Supreme Court.
What's that?
You have to have something to, enforce the Supreme Court's power.
Right.
Which I would know.
Okay, so this one is about displays, and this has actually been in the news even recently. But and again, look at the dates on all of these and all the previous slides. They're all after that 100-year mark where we kind of changed things and became a national rule. 1980, this is in Kentucky, they required the posting of a copy of the Ten Commandments. It was purchased with private contributions, right? But it was on the wall of each public classroom in the state, right? And they found it was unconstitutional because it lacked a secular legislative purpose. There was no secular purpose involved in putting those up there. They weren't even trying to teach law. They were putting it in every single classroom. So they found it unconstitutional. 1984, they upheld a public display of a creche, ruling that any benefit to religion was indirect, remote, and incidental. Okay. I found it interesting that they would do that, especially since 5 years later, they struck down a creche display because it occupied a prominent position in a county courthouse. So the first one probably wasn't a prominent position. Didn't have any necessary secular purpose, which I don't know why they wouldn't have knocked it down for that, but it wasn't in a county or a government position, so they didn't knock it down. The The one in 89, basically in Latin, read, for the glory of God. And it was in a prominent place, and they said it was their promoting religion, so they struck it down 5 years after they had just not struck one down. And then, so then the 2001 case, which you guys actually may be aware of. So this is the one where Chief Justice of Alabama put up the Ten Commandments and was ordered to take it down, and he denied. He basically said no, and he was booted out of office because he refused to comply. And Supreme Court, in this case, actually came up lower than the Supreme Court. I think it was a state court. The Supreme Court refused to even hear it. They weren't even going to listen to the court saying there's nothing to hear here. You were ordered to take it down, and you didn't, so you've lost your job. So in 2005, so this is the court upheld a 5-4 vote, the legality of the Ten Commandments display in a Texas state capitol due to the monument's secular purpose. So in this case, the Ten Commandments was in a courthouse, and they considered it a secular purpose because it was promoting law. I didn't see the difference between that and the one in Alabama. And then it was the same year that they had a Ten Commandments display in Kentucky courthouse, and they found that that one was illegal because they weren't integrated with a secular display. It implies that the other one was, but it's fascinating that the display question is fairly subtle because you're talking about Ten Commandments that could be considered religious, or it could be considered one of the early codified versions of the law. Think about the Supreme Court's difficulty in judging these cases, right? They have to look at that and what's the intent? Is your intent religious? Is your intent secular? Yeah.
We were just talking Sunday, and there has been in the news this recent ruling about this big cross. What was it in a? Yeah, and they kind of got around it by saying the cross was not a religious symbol.
Yeah,
therefore, they could, display it there. So it sounds like we have a court now that may be looking for some ways to start,
Was that a Supreme Court thing?
Yes, that was the Supreme Court.
Yeah, yeah. I'm wondering if they're
I don't know
starting to
how
look
you
at
can
ways
say
to
the
get
cross is not
around.
a religious symbol.
Well, they gave
Yeah.
the land that the cross is on, they made it private.
Yeah, and I was talking to somebody about that beforehand. That's a different argument than saying it's not a religious symbol.
Just the letter T, though, isn't it?
It's a little quick yeah. Lopsided.
With a body on it. Yeah, and I'm not sure where that one's going to go.
That's right, yeah.
Especially if it's now on private land. How do you even fight it, right?